So this is our third class on practice and procedure. Last time we have covered the appellate jurisdiction and we were on Article 136 of the Constitution of India. I have said that this article gives plenary power to the Supreme Court and it starts with non-obstante clause, which is notwithstanding. Notwithstanding, as I said, it's non-obstante clause and it gives overriding powers to the Supreme Court. So notwithstanding any other provisions of law, notwithstanding, so it starts like this. So this is a plenary power, it has got overriding jurisdiction, and I said that you all should remember this thing, that the Supreme Court's power under Article 136 of the Constitution of India is extremely wide, in the sense that it can grant leave to appeal against any judgment, decree, determination, sentence or order. So this jurisdiction is very wide, passed by any court or tribunal in India except Tribunal for the Armed Forces. And this discretion, as I said, that this is a discretion given to Supreme Court of India. So we had discussed certain judgments with regard to Article 136 of the Constitution of India. Yeah, if you see Article 136 of the Constitution of India, it is in two parts. So what happens that when you file special leave to appeal under Article 136 of the Constitution of India, you ask for grant of leave against the judgment and order or whatever passed by any courts or tribunal. So first stage is grant of leave, and thereafter, like if leave is granted, then Supreme Court passes the order. So what happens that normally, as last time I said that if you file normally what happens that there is a filtration process also, as I said, that because Supreme Court being the court of last resort, so SLPs are filed before the Honorable Supreme Court of India, and when the Supreme Court deems fit that the matter involves substantial question of law or should interfere, so in that case only notice is issued. So issuance of notice does not mean admission of SLP. So I said that I can't give it in percentage wise, but most of the SLPs got dismissed on the first day during the filtration process. So thereafter, when Supreme Court issues notice, in that case what happens that many cases Supreme Court in many cases you will find that Supreme Court, after issuance of notice, decides it, and in many cases Supreme Court grants leave, and thereafter the matter is decided by Supreme Court. So there are you will find in your examination paper a question with regard to doctrine of merger. This is very, very important, I tell you, with regard to res judicata and to what happens you file SLP and your SLP gets dismissed, then whether you have got any remedy to file review petition or not. So you will find every year you will find that this type of questions are being asked in the question of particularly practice and procedure in AOR examination. So there is a judgment, you can note down that judgment. It is Indian Oil Corporation versus State of Bihar, 1986, 4 SEC 146. So the question arose in this judgment that after dismissal of SLP, you have filed one special leave petition before the Honorable Supreme Court of India. and the Honorable Supreme Court of India has simply dismissed this matter without giving any finding, any observation, any reasons. So whether you can file review petition against the judgment of the High Court before the same High Court or not. So this question arose for consideration in Indian Oil Corporation, as I said, in that judgment. So in this case, the Honorable Supreme Court said that if your SLP is dismissed in limine, in that case review is maintainable before the High Court. So you can file review petition even after dismissal of your SLP. Now this position was clarified in Kunaiya Ahmad. Kunaiya Ahmad is very important decision. This is 2000 volume 6 SEC 359. You can note down this decision. So this decision, in this is a 3 judges bench decision. This case also considered about what happens when you have filed special leave petition and your special leave petition is dismissed. So what happens when your special leave petition is dismissed with some speaking order, or what happens when your special leave petition, that is the leave is granted by the Supreme Court and thereafter it is dismissed without any observation as such. So what happens in that case? So in Kunaiya Ahmad, this question was considered. As I told you that every year you will find that questions are being asked. As I told you that SLP, what happens that when you file special leave petition before the Honorable Supreme Court of India, you ask for grant of leave. Why you ask for grant of leave? Because you have not filed a petition under any you have got no right to appeal, because there is no right to appeal. No statute has provided any right to appeal. Therefore, you have filed petition under Article 136 of the Constitution of India. You file under Article 136 of the Constitution of India since there is no certificate by High Court. Having High Court given you certificate under Article 132, 133 or 134 of the Constitution of India, there was no need to file any special leave petition before the Honorable Supreme Court of India. Second thing, if you have got any remedy by virtue of the statutory provision, as I said, that there are statutory provisions like Section 30 of the Advocates Act, where you have got a right to file appeal before the Honorable Supreme Court of India, 116A of the Representations of the People Act. Here also you have got right to appeal, right to file appeal before the Honorable Supreme Court of India. Questions are being asked about the statutory rights also. So here under Article 136, you ask for grant of leave to appeal. So what happens? I said that normally when you file SLP, so there are so many SLPs, most of the SLPs got dismissed also, where Supreme Court finds that there are reasons to interfere. In those cases, Supreme Court issues notice, and if Supreme Court thinks that question is short, it can be decided. So normally what happens, that Supreme Court grants leave and then and there disposes of the petition after some speaking order. And yes, and there are certain cases where Supreme Court will grant leave and just leave the matter. And so after grant of leave, when you get the leave, your appeal, if it is civil in nature, then it will be converted to a civil appeal. Or you have filed special leave petition, criminal special leave petition, in that case it will be after grant of leave, your SLP criminal will be converted to criminal appeal. So now thereafter, after grant of special leave, you get this right of appeal also. So I was talking about the decision, what happens when Supreme Court, suppose you filed SLP before Supreme Court and Supreme Court dismisses your SLP, whether you have got any right to review or not, whether you can file review I am not talking about review to be filed before the Honorable Supreme Court. That right you have got under Article 137 of the Constitution of India. I am talking about review, whether you can file review against before the High Court or not. So this question was considered, I said, that Indian Oil Corporation case and thereafter Kunia Ahmed case. Now Kunia Ahmed is a 3 judges bench decision. It says that if your SLP is dismissed in limine or even some speaking order has been passed, even thereafter you can file review petition before High Court, because in that case if your SLP is dismissed in limine or even with some speaking order, doctrine of merger does not apply. So this is very important. You all should know as to what is the doctrine of merger. Doctrine of merger is the merger of the operative part. Suppose some in criminal matter a person has been convicted and sentenced and for some period, suppose 7 years. He files appeal before the Honorable High Court of India, and the Honorable High Court modifies that appeal or allows that appeal in part and then reduces the sentence to 5 years. So as per doctrine of merger, this 7 year the operative part of the judgment will merge with the High Court's judgment. So the question arose that suppose in SLP is filed before the Honorable Supreme Court of India and SLP is dismissed, whether this doctrine of merger will apply or not. So Supreme Court in Kunia Ahmed said, if your SLP is dismissed, in that case doctrine of merger will not apply. But if Supreme Court grants leave, meaning thereby your SLP is converted to a regular appeal, in that case this doctrine of merger will apply. So now thereafter, now a question arose as to what happens, if suppose High Court's order is challenged before the Supreme Court of India and Supreme Court dismisses that SLP. Now thereafter you file a review petition before High Court and that review petition gets dismissed by High Court. So whether you need to challenge both the main order or the order of review, in that case the Honorable Supreme Court said, not in Kunia Ahmed, in other subsequent judgment, that as per Order 47, Rule 7 of CPC, you need to challenge both the orders. Why? Because review is not the main order, it is only review of the main order. Therefore, when you, in those circumstances, questions are being asked with regard to that also. So in those circumstances, when you feel that, when you find that the High Court has dismissed it by main order and thereafter you challenged it in review and your review also get dismissed, in that case you need to file SLP before the Honorable Supreme Court of India against both the main order as well as the order in review. Now the Kunia Ahmed case was now the question arose in Abhishek Malviya case with regard to maintainability of the special leave petition under Article 136 of the Constitution of India, where a High Court's order was challenged before the Honorable Supreme Court. Supreme Court dismissed that order without granting any liberty, and in that case that person again approaches High Court by way in a review petition, and his review petition also gets dismissed. Then whether he can again file SLP or not. So in Abhishek Malviya said, because see, if you see, Kunia Ahmed is a 3 judges bench judgment. Kunia Ahmed has not laid down any such thing. Kunia Ahmed has simply said that doctrine of merger does not apply, and also dealt with the other aspect of the matter about res judicata or not. But Kunia Ahmed does not say that you need to have a liberty from Supreme Court for coming again. But if you see Abhishek Malviya, this is 2008 3 SCC 108. As per this decision, if you file SLP against the main order of the High Court and then you want to withdraw it and again want to file a review before High Court, in that case you need to take liberty from the Supreme Court for coming back to Supreme Court against any order passed in review by the High Court. Now, this decision was further considered in Vinod Kapoor. Vinod Kapoor is also Abhishek Vinod Kapoor is 2012 12 SCC 383. This decision also reiterated the same view that in that case you need to take liberty from the Supreme Court, stating that you want to file review before High Court, and if High Court and you may have that liberty to challenge the order of review as well as before the Honorable Supreme Court. Then only your SLP is maintainable. Sandhya Education Society also said the same thing. So I will tell you about the citations. Abhishek Malviya is 2008 3 SCC 108. Then Vinod Kapoor is 2012 12 SCC 383. Sandhya Education Society is 2014 7 SCC 701. In Sandhya Education Society also, a two-judge bench of the Supreme Court accepted the principle laid down in Vinod Kapoor and stated that once special leave petition is dismissed as withdrawn and there is no explicit liberty to come back, then your SLP is not maintainable. Now again, see, so as I told you, as I said that Kunia Ahmed did not prescribe any such thing, but subsequent judgment like Abhishek Malviya, Vinod Kapoor, Sandhya Education said no, you need to take liberty, otherwise this is Supreme Court, this is not a joke. Like it's not that you come here, your SLP is dismissed, you go back before High Court, file a review, your review is dismissed, then you can come again back to Supreme Court. So Supreme Court said no, nothing doing. But Khoda Industries, Khoda Distilleries, you may note down this decision, this is a very important decision. Khoda Distilleries Limited is 2019 4 SCC 376. Now this decision followed the principles of Kunia Ahmed and said that doctrine of merger is not applicable. So once your SLP is dismissed, you can file review before High Court, and against the review order you can come to Supreme Court. So there are two views which is very clear from two line of judgments, but I would tell you that Kunia Ahmed and Khoda Distilleries are judgments passed by three judges. Now in S. Narhari, the Supreme Court also noted this controversy and has referred the matter to a larger bench. So you may note down this decision. S. Narhari, this is 2023 7 SCC 740. This is decision of passed by Honorable Justice Krishna Murari, if I am correct, and the Honorable bench has referred the matter to a larger bench so that this confusion may be cleared whether you need to take a liberty or not when your SLP is dismissed, right? So in the last lecture we had discussed about the courts and tribunals Because I said that in Article 136 you can file SLP against the order of tribunal also. So we had discussed about tribunal also, and I had stated about two decisions, which is Bharat Bank Limited and Hind Cycles. So I had also stated that arbitral tribunal is not a tribunal within the meaning of Article 136 of the Constitution of India. Why arbitral tribunal is not a tribunal within the meaning of Article 136 is because the state has not invested any judicial power to the arbitral tribunal to decide a matter. So what happens that in agreement normally you opt for arbitration, parties opt for arbitration, and in compliance of that arbitrator is appointed. So arbitrator is not appointed by virtue of this arbitral tribunal has not been given any powers of the state, but it is chosen by you or it is appointed by the courts also, and therefore arbitral tribunal is not a tribunal within the meaning of Article 136 of the Constitution of India. Now thereafter I can give you in 136 you will find that against interlocutory orders, sometime when there is pressing need, you file special leave SLP before the Honorable Supreme Court of India, SLP under Article 136. So you can see a judgment which is Swadeshi Cotton Mills. If you like, you can note down also. This is 1986. I don't know, maybe wrong. This is I will give you about the citation, 1986 SCC 296. I'll give you what is the volume number. So in this case, the Honorable Supreme Court says that Supreme Court is not going to interfere in routine manner, like you file any SLP against an interlocutory order, and Supreme Court is not going to entertain all those things. So Supreme Court said that, when the repercussions are incalculable, like incalculable harm would be done, or like by an interlocutory order final relief has been given, in those cases only Supreme Court will interfere. And as I said that though Supreme Court has been invested with the powers under Article 136 so that to entertain any SLP against any order, judgment and all those things which I said, but care must be taken always to exhaust the remedy, then only you should come to Supreme Court. It's not that some order has been passed and you challenge it before the Honorable Supreme Court of India by invoking the jurisdiction under Article 136 of the Constitution of India. See, this jurisdiction is discretionary and there are certain responsibilities also on all the advocates and the advocates on record who file this petition. So better always to exhaust the remedies and then only you should file a special leave petition before the Honorable Supreme Court of India. As I said that interlocutory order, care must be taken that you should not come unless and until there are pressing needs and all those grounds as mentioned in Swadeshi Cotton Mills are satisfied. Now there are judgments also. If I can circulate it in the group, whereby the question arose before the Honorable Supreme Court that if a person has filed, if a convict has filed special leave petition before the Honorable Supreme Court of India, and in petitioners, in convicts SLP, whether Supreme Court can enhance the sentence or not. So Supreme Court has answered this question in affirmative, in yes, saying that when there is when Supreme Court feels that there is miscarriage of justice, or that person, that convict sentence needs to be enhanced, in that case Supreme Court may issue notice for enhancement and may enhance it also. So you should be very careful also in those cases. Normally it does not happen. I don't remember particularly, I don't remember any case where in my memory whether Supreme Court has issued such notice, but we need to be careful also. There is a judgment, State of Assam versus Brojen Gogoi. In this case, you know what happened, that Article 136 SLP was filed before the Honorable Supreme Court, and particularly the challenge was the anticipatory bail order passed by the Bombay High Court. Bombay High Court had given anticipatory bail to a person. The Assam, State of Assam filed special leave petition before the Honorable Supreme Court of India challenging the order of grant of anticipatory bail by State of Bombay, and stated that the territorial jurisdiction was State of Assam and the matter ought to have been entertained by State of Guwahati High Court and not the Bombay High Court. So that in that SLP, Supreme Court treated it like an application under section 406 of CRPC and transferred that matter from the Bombay High that matter to the Guwahati High Court. That application for anticipatory bail, the Supreme Court set aside the order passed by Bombay High Court granting anticipatory bail and transferred the matter to Guwahati High Court. See, as I said that when you file SLP, you need to take care of so many things, and you should also take care of the things that you should not try to mislead, you should not try to conceal any information which has got bearing on the case. This aspect has also been dealt with by the Honorable Supreme Court, and there are important judgments with regard to that on suppression of material facts. You can note down this judgment. This is Hari Narayan versus Badri Das, 1964, 2 SCR 203. In this judgment, the Honorable Supreme Court said that you should take care. Care must be taken not to make any statement which are incorrect or which are untrue, and you should not try to mislead the Honorable Supreme Court. And Supreme Court said that even if we have granted leave, we can revoke leave on your material suppression or on misleading statement. So care must be taken with regard to that also. Now the question arose with regard to locus standi as to who can file special leave petition to the Honorable Supreme Court of India. The Honorable Supreme Court said that we have not, Constitution has not given power to anybody, nor Constitution inhibits anybody. Means Constitution does not say that you should or you can file special leave petition, or Constitution does not stop anybody also in filing special leave petition before the Honorable Supreme Court of India. So this question of locus was considered by the Honorable Supreme Court in PSR Sadanantham versus Arunachalam. This judgment you may note down, this is 1979 2 SCC 297. Now in this judgment, the Honorable Supreme Court, as I told you, has said that it has not, Constitution has not conferred anybody with the power, as I mentioned, to invoke the jurisdiction of SC, and nor inhibits. Now same thing, there is one more judgment, V.S. Achyutanandan versus R. Balakrishnan Pillai. V.S. Achyutanandan versus R. Balakrishnan Pillai, this is 1994, 4 SCC 299. Now in this case, I don't know whether I have mentioned this fact or not. R. Balakrishnan Pillai, once a minister, was convicted by a trial court, but he was acquitted by High Court in the appeal filed by R. Balakrishnan Pillai. V.S. Achyutanandan was not a party in that matter. He filed special leave to appeal before the Honorable Supreme Court of India, challenging the judgment of acquittal passed by High Court. In that matter, the Honorable Supreme Court entertained it and allowed the special leave petition filed by V.S. Achyutanand. If Sachin wants to say something, do you want to say anything? I think it would be better if I complete my class and thereafter I can come back to you. Now, a question arose in Supreme Court because see, as I told you about Kunia Ahmad and I told you about the other judgments, that what is the stage, what happens, you file SLP and thereafter sometimes Supreme Court dismisses your SLP. Sometimes what happens that Supreme Court issues notice, other side comes and thereafter in a short hearing Supreme Court decides it. So you will notice when Supreme Court decides your SLP, so normally the word used is leave granted and thereafter Supreme Court would pass the order, meaning thereby your special leave which you are asking for was granted and Supreme Court has passed certain directions which may be in your favor or which may be against you. So as I said that there are two stages. So Tahira Khatun is a very, very important judgment. This is an ammunition with the Supreme Court judges, I tell you. Why? Because even after grant of leave, suppose you have filed SLP, special leave petition, Supreme Court grants leave and thereafter after grant of leave, the matter comes after 5 years or like 4 years. And at that stage also, when after grant of leave, your SLP has become civil appeal or criminal appeal, Supreme Court can dismiss it, like without any detailed judgment. It's not that when your appeal is admitted, when Supreme Court has granted leave and it has become an appeal, in that case also Supreme Court in its discretion may decides it. This is the judgment, you may note down. This is Tahira Khatun 1999 to SEC 635. So in this judgment, Supreme Court says that the power of discretion which was with the Supreme Court at the time of Article 136 of the Constitution of India, that power remains it itself. It is not required that after grant of leave, Supreme Court will pass a detailed judgment or order. It may simply dismiss your appeal, civil appeal or criminal appeal or whatever it is. So as I said that this is an ammunition with the Supreme Court, Tahira Khatun, and the very helpful to the judges. Now there are what happens, if you see the rules regarding filing of special leave petition, you must see Order 21 and Order 22 of the Supreme Court rules. So for filing special leave petition before the Honorable Supreme Court, the limitation period is 90 days. So you have to file petition within a period of 90 days. And when there is any delay, in that case, you can file an application for condonation of delay in filing SLP. That application for condonation of delay would be accompanied with your special leave petition. So normally I have seen that 100 days, 200 days, normally Supreme Court condones the delay and then hears the matter on merit. I have seen that many times. What happens that SLP is filed before Supreme Court and there is an application for condonation of delay also, and the main matter is being argued, and last, when Supreme Court issues notice, then the lawyer says or the court master says that there is some delay also. So if the delay is like a few days of 100 or 200 or 300 days, then the Honorable Supreme Court condones the delay. And when the delay is more than a reasonable period, in that case Supreme Court issues notice on condonation of delay also. And when there is unreasonable delay and where there is unexplained delay, or when the Supreme Court is not satisfied, even like Supreme Court, you have filed a petition before Supreme Court, Supreme Court is is inclined to issue notice, and Supreme Court issues notice also, and then court master points out, or you point out that Lord, there is some delay also. So Supreme Court will see, the judges will see as to how much is the delay, and when Supreme Court finds that no, delay is not reasonable, it's unreasonable, in that case Supreme Court would ask you about the explanation also, and when convinced, then Supreme Court may issue notice on delay. And when then delay is unreasonable, then your special leave petition may be dismissed also. I can tell you about one judgment which is very helpful to many of the advocates. This is that judgment is Mrs. Cartige's judgment, Collector Land Acquisition Anantnag versus Mrs. Cartige. This is 1987 to SCC 107. In this case, if I am correct, a huge period of delay of some 10-11 years was condoned by the Honorable Supreme Court. Obviously Supreme Court would have noticed the reasons, and then Supreme Court held in that decision that when the substantial justice and technicalities are pitted against each other, in that case substantial justice must be given consideration. So this case is an exception. I will say that this is not a rule, but we should be very careful to file the petition within limitation period, that is within 90 days. And suppose if there is any delay, in that case you will have to file this application for condonation of delay. Now as I mentioned, because you will find that questions are being asked, I am repeating for the sake of repetition, that you would be asked about the appellate jurisdiction provided by statute. So you should, as I said, you should see the Advocates Act, section 38 of the Advocates Act, 116 of the Representations of the People Act, section 22 of the NGT Act, 130T of the Customs Act, section 53T of the CCI Act, 261 of the Income Tax Act, and like other jurisdictions also. You should see about those things, and you need to write down about that. So I had also said, if I remember correctly, in my last lecture, in my last session, that whether you have got statute provides a right to appeal to you. So is it required for the Supreme Court to give a detailed hearing and give a detailed judgment? And is it mandatory for the Supreme Court to issue a notice in this matter? Or there is any distinction between the manner in which the petition under Article 136 is decided and the petitions under the appeals under the statutory provisions are decided? So see, I can say that I have not seen, if you ask me the practical experience, I have not seen that there is any such distinction. When the Supreme Court finds that there is merit in the special leave petition, Supreme Court normally issues notice. And when Supreme Court sees that there is merit in the statutory appeal, in that case also Supreme Court would issue notice and admit the matter, right? But if Supreme Court thinks that no, there is no merit in this matter, and it's sheer wastage of time, in that case Supreme Court may dismiss the statutory appeal also. So I have stated about the judgment, which is O.N. Mahendru. This is 1968 to 2 SCR 709. In this case also, Supreme Court says that your statutory appeal can be dismissed summarily without even issuing notice. In this case, an statutory appeal under section 32, statutory appeal under section 38 of the Advocates Act was filed before the Honorable Supreme Court, and Supreme Court held that there is no need to issue notice or whatever gave that judgment. So we have, like, see, Article 136 is just like an ocean. Like I said, that there's so many petitions filed under Article 136 of the Constitution of India, so many decisions. So I have just tried to cover some important judgments which I think is relevant for the purpose of AOR examination. Now we can move forward and we can come to review. As I said that Constitution of India, Article 137 of the Constitution of India has given power to the Honorable Supreme Court to review judgment and orders of Supreme Court. So as I had mentioned it in my last lecture also about the procedure which is followed in review petition. You must see Article 137 and you should also see Order 47 of the Supreme Court rules. If you see Order 47 of the Supreme Court rules, then the Supreme Court says that the court, the rule says, Order 47 of the Supreme Court rule says the court may review its judgment or order, but no application for review will be entertained in a civil proceedings except on the ground mentioned in Order 47, Rule 1 of the Code. Here code means the Code of Civil Procedure, CPC. So the grounds mentioned in Order 47 of the CPC are applicable for filing review petition before the Honorable Supreme Court of India in civil matters. And if you see this Order 47 of the rules, please don't be confused here. Review, as I said, Order 47 of the Supreme Court rules prescribes the method, like the rule says, as to when a review is maintainable. Order 47 of the Supreme Court rules that you can take all those grounds, it is maintainable on the grounds of Order 47(1) of CPC in civil matters, and the review is maintainable in criminal matters on only ground of an error apparent on the face of record. So there is a distinction between review petition between review petition in civil matter and in criminal matter. In criminal matter, it is restricted only to the error apparent on the face of the record. It is not that you cannot bring any new fact or all those things. Those grounds are not maintainable. But I would take you, I would tell you about one judgment which is very important, which is This judgment is PN Aishwarya Iyer 1980 4 SCC 680. So in this case, the Supreme Court repealed that contention. No, it's not that. In this case, Supreme Court repealed that contention. Supreme Court said that no, it's not that in criminal matters only on error apparent on the face of the record review is maintainable. Supreme Court says that what happens in a case like suppose a person a deceased, a person is charged with killing a person A, and that person's conviction get upheld by High Court as well as by the Honorable Supreme Court of India. So what happens that the A for whose death a petitioner, a person has been convicted, he comes up, he shows up. पता चलता है कि वो आदमी तो जिंदा है जिसके मारने के लिए उसे सजा मिली थी, that person is alive. So what happened that whether Supreme Court should shut its eyes and say that no, I can't do anything because we don't have any power. We can only correct the error which is apparent on the face of record. Supreme Court said no. It's not that we are not. It's not that we are restricted by only such thing. And if you see Order 48, Supreme Court has been given inherent powers also. So in review petition also, Supreme Court can exercise its inherent power. Now there is a judgment, Muhammad Arif. This you may note down. In my view, this is an important judgment, and questions are being asked with regard to this judgment also. And now Supreme Court rules has been amended in accordance with this judgment. Muhammad Arif, this is 2014 9 SCC 737. This is Justice, if I am correct, Justice R.F. Nariman has delivered this judgment. Now, in this case, the Honorable Supreme Court held that the review with regard to a matter pertaining to death penalty, it has to be entertained by 3 judges, and that too in an open court. So after this judgment, what is happening that any matter, Supreme Court has changed its rules also, and any matter where death sentence, with regard to death sentence, a 3 judges bench of Supreme Court entertains those matters, and when the main petition, when the SLP is dismissed, in that case, if you file review in a death sentence matter, it would be heard by a 3 judges bench, and that too in an open court. So you may note down that judgment. I said that this judgment is very, very important. Apart from that, in review, there are other judgments also, like Lily Thomas, which says that review is not an appeal in disguise, as if your SLP is dismissed or your appeal has been dismissed, and you are filing review. It's not an appeal to that order. It's not an appeal of appeal. So only on those grounds, when there are error apparent to the face of the record, or when there are compelling reasons, only in that case review petition is maintainable. There are other judgments also. It may take some time, but one important judgment I would tell you. This is Abdul Karim. This is 2007 2 SCC 466. Abdul Karim, APSRTC versus Abdul Karim, 2007, volume 2, SCC 466. Now see, what happens that we all know about review petition except death sentence matter. When you file a review petition, your review petition would be listed before the judges in chamber. So, and it will be like they will decide it in chamber, and normally it get dismissed also. So very cleverly what many lawyers do is that after disposal of any judgment or order by Supreme Court, an application for clarification or an application for modification would be filed. Why? Because of the reason that we all know that review is normally is not heard in open court. So when you file any application for clarification or modification, all those applications would be listed before the court, and there would be open court hearing. But in that matter, Abdul Karim, the Honorable Supreme Court deprecated that practice and said that what can't be done directly, you cannot do it indirectly also. So all those applications for clarification, modification in the are in the nature of review, and those applications should not be entertained. So after review, we can come to Article 141. Article 141 of the Constitution of India is very, very important, because this article says that law declared by Supreme Court to be binding on all courts in India. So by virtue of Article 141, the Supreme Court's decisions are binding. When you read Article 141, you please also see Article 144 of the Constitution of India. It should have been there. Yes. So 144 says that civil and judicial authority to act in aid of the Supreme Court of India. So first thing, that Article 141, law declared by Supreme Court is binding on all courts, and 144, that all courts and tribunal, whatever, they have to aid. It's not that, it would be binding only when the other authorities follow it also. So it has to be read along with Article 144 of the Constitution of India. Now the question arises as to what is binding, because it says law declared by Supreme Court is binding. So you must be very, very clear that it is the law which is binding on all courts. So what is the law? That you have to decide, that you have to see the principles. We can yes, Shruti. Anyways.
So yes, sir.
So can we go? See, I want to cover. So 6. I would like to take it till 6:10.
Yes, sir. Everyone is here. We can continue. No issue.
Okay. Because in that manner we would be able to cover.
Right.
Yes. So I was saying that Article 141 says that law declared by Supreme Court. So the question is, what is, so you'll have to see what is the principle of that decision, which is ratio. Questions are normally asked, because if you appear in our examination, you may be confronted with the questions as to what is ratio descendendi, and then what is stare decisis, what is per incurium, what is sub silentio. So it is the ratio of the decision which is applicable. So you need to, whenever you read a judgment, you should read in such a manner as to you can deduce the principles of law as to what is the principles of law enumerated by the Supreme Court, which is binding. It is Queen versus Letham, or you can see Ambika Query Works. Ambika Query Works is 1987, 1 SCC 213. So in this judgment, Supreme Court approved the principles of Queen versus Letham. This is 1901 judgment, 1901 judgment, and Supreme Court held that the ratio is the rule which is deducible from the application of law, and the ratio must be understood in the background of the facts of the case, and a case is only authority for what it actually decides and not what logically follows from it. So you must see as to what are the issues involved and the decision of the Supreme Court on those issues. Suppose if the issues like are involved are something else, and Supreme Court says with regard, not with regard to that those issues, but with regard to something that it should be done like that, or we feel that, so those excerpts are only obiter, those are not the rule, those are not the ratio. Ratio is only that part which covers the issue. Issue is precisely this, and the Honorable Supreme Court on those issues has decided this, right? So this ratio, this you may be confronted with this question.